Welcome to the West Virginia Legislature on the West Virginia Channel. I'm Beth Voorhees. We are awaiting the second public hearing this morning at 9 o'clock in the House chamber for Senate Bill 6, requiring drug screening and testing of applicants for temporary assistance to needy families, requiring drug testing of applicants for whom there is reasonable suspicion of substance abuse. The sponsors of this bill are Senators Ferns, Carmichael, Gaunch, DeCubo, Trump, Prezioso, Stallings, Plymel, Blair, Carnes, and Seipold. The bill passed the Senate 32-2 on February 9th. The bill was approved by the House Health and Human Resources Committee on February 10th, and the bill has been before the House Judiciary Committee since February 12th, and this public hearing is before the House Committee on the Judiciary. We will join this public hearing as soon as it begins. This is Beth Voorhees. There's some sort of audio problem coming from the House of Delegates chamber. Legislative staff is working on it, and we hope to have audio back very, very soon. Please stand by.
But in this case, particularly with the limited resources the state has to offer at this time, we feel the state should respond to this epidemic with evidence-based research. Given that the rate of substance abuse is no greater among low-income families than higher-income families, experience in other states, in implementing drug testing and the diversion of funds that could be used for treatment, the Council opposes drug testing of persons receiving public assistance. Targeting persons who are low income just because they're low income is demeaning, fails to recognize their humanity created in the image of God, and may do more harm than good. We agree with the urgency to respond to the substance abuse crisis in West Virginia, but feel that these funds would be better spent in prevention and recovery. Thank you.
Thank you, Mr. Wilson. Dr. Sarah Jarvis, followed by Sean O'Leary. And when your name is called as a follow-up presenter, if you would move closer to the podium, that way it'll save a little bit of time.
Thank you, Mr. Chairman. My name is Dr. Sarah Jarvis. I am a licensed West Virginia psychologist. My clinical practice focuses on treating those addicted to substances. I am speaking in opposition of Senate Bill 6 for one reason: financial responsibility. We are all aware of the ravaging effects addiction has had on our communities as a whole. Testing this small subgroup of the population helps no one. We know that there is a problem and that it is greater than just those receiving TANF benefits. Drug kits, nursing staff, the testing procedure are incredibly costly to an already strapped system. It is my hope that instead of spending time and money into testing presumably innocent, needy families, that we invest in the long-term future of West Virginia through expansion of prevention efforts and through use of supportive, effective, evidence-based treatments for addiction. Here, a global difference can be made for our communities and those affected with addiction. Thank you for your time. Thank you, Mr. Chairman.
Thank you, Dr. Jarvis. Sean O'Leary, followed by Eli Baumwell.
Hello, my name is Sean O'Leary. I'm the Senior Policy Analyst at the West Virginia Center on Budget and Policy, and I'm here to speak in opposition today to drug testing TANF recipients. Drug testing TANF recipients is quite simply bad policy. The purpose of the policy would seem to be addressing the state's substance abuse problem and possibly saving the state money, but there's an abundance of evidence showing that these programs fail to achieve either goal. First, the fiscal side. Policies to drug test TANF and other recipients of state benefits are often sold with a promise of saving state money, or at least being inexpensive. Instead, programs in other states have proved to be very expensive to implement and run, with some costing millions of dollars. A recent analysis of 12 active state drug testing programs from the U.S. Department of Health and Human Services found that none of the programs have produced any state savings. But beyond that, more importantly, these policies also fail at discouraging substance abuse and getting help to those who need it. Policies in other states have overwhelmingly failed to find any significant number of substance abusers among the recipients of cash assistance. Reports on drug testing policies from states like Arizona, Florida, Missouri, Utah, Oklahoma, Kansas, and Tennessee have identified only a handful of substance abusers out of tens of thousands of cash assistance recipients. According to research published in the American Journal of Public Health, the percentage of welfare recipients using illegal drugs is relatively small and consistent with the rest of the population. In other words, those receiving assistance are no more likely to be using drugs than those who are not. So why are we only targeting the poor with this proposal? The experience of basically every state that has tried drug testing TANF recipients has shown that it fails at identifying any significant number of substance abusers. So how is this policy going to help those who need help if it can't find anyone who needs help? Why is it only looking at a small portion of the population? The answer is we're not helping anyone with this policy. Proposals like Senate Bill 6 are based on stereotypes and anecdotes about the prevalence of substance abuse among recipients, not evidence. The fact is, drug testing welfare recipients is a flawed and inefficient way at identifying people who need treatment. And no study has ever shown that denying assistance facilitates those who need help getting treatment. Investing in substance abuse treatment is an efficient use of taxpayer dollars, but expensive and unnecessary policies that are based more on stereotype and punishing the poor rather than on facts and evidence are not. If West Virginia needs to tackle its substance abuse problem, but we need to look at what works. Thank you.
Thank you, Mr. O'Leary. Eli Baumwell, followed by Sierra Pennington.
Thank you, Mr. Chairman, and thank you, members who are here. My name is Eli Baumwell. I'm Policy Director with the American Civil Liberties Union of West Virginia. I'm here to voice the ACLU's strong opposition to Senate Bill 6. Our legal director is going to speak more about some of the legal concerns we have with this bill. I want to talk about the policy issues. But before I do that, I'd like to speak from a personal note. Prior to taking this position with the American Civil Liberties Union, I served as a representative representing people on Social Security disability claims. When I did that, I saw firsthand how programs that create barriers between people who are on a sustenance level of living and these benefits can hurt them. It happened in Social Security, and actually a lot of my clients were on TANF, and I saw it happen to those people too. I had clients, more than one, who went from being good, hardworking people, contributing members of our society, to being injured or ill, lost their houses, had to put every belonging that they had into storage, and then lost those when they couldn't pay those storage fees anymore, had every belonging, every photograph, every memento of the life that they had sold or thrown away. I'm not sure if I can convey how much that destroys a person, but I do know it, because they were my clients, and they would call me crying, and I would have to tell them that they just had to wait longer, that there were more barriers and more hurdles. That destroys a person, and I don't think that there's any way that we can justify doing that to a person when that's the difference between sustenance and utter ruin. Now, if that's not enough to give you pause, the evidence is clear that this is also bad public policy. Of the 13 states that have enacted legislation like this, almost all of them have lost money on these sorts of programs. Even in states where they've used a suspicion standard, where they're trying to narrow down the number of tests that they're actually doing, they still don't save money. States that have claimed to save money, like Oklahoma, have done so by pointing to individuals who don't take the tests. When that may mean the states are paying less money in TANF benefits, but these are then families and children who don't get those benefits. These are people who choose drugs over going out and working. So we aren't achieving our goals of helping these individuals get back up on their feet. Losses have been found even in states that only calculate the cost of drug tests. These programs cost a lot more than just the drug test. There are things like the screening tools, developing and implementing these tools. There's confirmation tests. As Senate Bill 6 requires follow-up tests. So there are additional costs throughout this, not to mention the cost of a drug treatment program, of a job training program. But even in the states where they have looked just at the cost of these tests, states have lost money. Now, part of the reason that they've lost money is they're not identifying a lot of drug users. And that's because drug use is not rampant among the poor. This is played out in other states. For example, in Mississippi and Arizona, they found 2 and 3 drug users, respectively, over the course of a year. 2 and 3 drug users, respectively, in those 2 states. Overall, when they test people, they found as little as 0.2% of the people tested have tested positive, up to, in some states, as high as 10%, which just matches the national average. So again, we know that these programs don't work. There are other problems in terms of these programs' ability to help people. Drug treatment beds are rare in West Virginia, and we've only been able to justify them by pointing to methadone clinics and saying those are available. We also know that people are required to go to a job training program, even though TANF already requires you to be working, and many TANF benefits do work, or may be disabled and may be unable to work, and we're forcing these people to go to job training as well. So for all these reasons, I urge rejection of Senate Bill 6. Thank you very much.
Thank you, Mr. Baumwell. Sierra Pennington, followed by Betty Rivard.
Hi, my name is Sierra Pennington, and I'm here to oppose Senate Bill 6. First, I'd like to make the point that this is an invasion of privacy. People would have to disclose their medical conditions to explain why they have prescription medications showing up in the drug test. And that could be stigmatizing because there's a lot of people with mental illness and other things. Secondly, almost everyone receives government assistance in some way, Yet we don't drug test everyone. Why are we picking on the poor? And finally, I'd like to make the point that no evidence points to public assistance recipients being more likely to use illegal drugs. As Eli said, other states have done this, and it's been very low return on investment. All of this just further leads to demonizing and stigmatizing the poor. As someone who grew up in a low-income family, this really upsets me. We grew up always using Medicaid, we had food stamps, we applied for TANF, we did not receive it, but still the point stands. We were low income, and I remember the times of kids making fun of me, making fun of my sisters and my brother for being poor. You all were elected to be leaders, so I'm calling on you to be leaders and help end this stigmatizing situation of saying the poor are druggies or abusing these systems that they so need to live the lives that everybody else lives. So with that said, I urge you to oppose Senate Bill 6. Thank you.
Thank you, Ms. Pennington. Betty Rivard, followed by Carrie Jo Grace.
Thank you for the opportunity to speak. I oppose Senate Bill 6. I'm Betty Rivard, a social worker emeritus, photographer, and independent citizen advocate. I had originally planned just to attend this hearing, but I was requested to speak. As I researched the bill earlier this morning, I realized that it is totally flawed in a way that no one whose comments I've seen or heard has addressed. As background, during the 1990s, before I retired after 25 years as a social worker and planner with DHHR, I had responsibility for monitoring and negotiating legislation based on the best interests of children, families, and adults who are elderly or have disabilities. I became very attuned to fine points in bills and their effects on the child welfare and other social services systems. I frequently was able to pick up on things that the DHHR secretary and her immediate advisors and the legislators and their attorneys and analysts might have missed. In reviewing Senate Bill 6, I was shocked to see a section 936CH that has critical effects on the child welfare system. The first sentence in H states, quote, "The Secretary shall order an investigation," shall is the operative word, order an investigation and home visit from Child Protective Services on any applicant who is declared ineligible for failure to pass a drug test, unquote. With an estimated 122 failed drug tests per year and a minimum of 10 hours per case, and this is really a minimum with all of the responsibilities, this causes an extra workload of something like 1,220 hours per year for an already overtaxed system at a cost of approximately $200 per case, in addition to the cost for the drug tests. These extra costs are not addressed in the fiscal notes submitted by DHHR. In addition, quote, "Child Protective Services is responsible for providing, directing, or coordinating the appropriate and timely," and again, that's an operative word, "delivery of services to any child who is the subject of any investigation and home visit conducted pursuant to this section," unquote. So again, the operative word here is timely. Does this mean giving priority to work on this as opposed to protecting children who are at immediate risk of severe abuse or neglect? How does this compete with other priorities? The only cross-reference I saw to Chapter 49, which is the part of the code that addresses child welfare, is in the definitions. But this has grave impact on the work and priorities based on Chapter 49. Another factor is the requirement that the Secretary approve any protective payee designated to oversee TANF funds for a child whose parent is ineligible where they don't have someone else to do it. Who will do that, and what are the costs? I urge you to reject this very flawed bill based on these factors and others that some of the other speakers have outlined and may outline. I'm available for questions, and I thank you again for the opportunity to speak, and I'll leave a copy of my remarks.
Thank you, Ms. Rivard. Carrie Jo Grace, followed by Lida Shepherd.
Okay, thank you for the opportunity to speak. My name is Carrie Jo Grace. I am with West Virginia Healthy Kids and Families Coalition, and we oppose Senate Bill 6. A lot of the previous speakers have covered some very important points, but my first reason for opposing this bill is a personal one. Being poor isn't fun, and given the option, parents would never choose to raise their kids in poverty and all of the implications that come from that. I struggled to raise my kids, and before I got this position, I was on food stamps. I was homeless. I didn't know where we were going to live and how we were going to pay our bills when we did find a place to live. Going and asking for assistance can be a humiliating experience. When you're leaving a house because of abuse or because of somebody else's drug abuse or because you've been kicked out or because you've lost a job is stressful enough. And then having to worry about getting a drug test and what if you're on a medication that would cause you to fail that drug test just adds another level of stress to an already bad situation. Folks have already mentioned that poor people are no more likely than others to abuse drugs. And we don't require others who get assistance to submit to drug testing, people on disability, people on Social Security, people on Medicaid or food stamps, people who receive subsidies from the federal government to help pay for their health insurance, or corporate CEOs whose companies receive government subsidies. My personal reason for opposing this bill is because it's just another slap at being poor. And I don't understand why we have to pick on the poor all the time. But other reasons that might resonate more with the legislative body are that drug testing of TANF recipients is expensive. And we're asking TANF recipients to cover further drug testing if they fail the initial one. These are people who don't have money to start with. It's also shown in many states to cost more than it saves and has shown a very, very low rate of drug abuse, just like in the rest of the population. We don't deny that drug abuse and drug addiction are terrible, terrible problems, but the way to solve those problems is to provide more treatment centers, more beds, and more support for people who are trying to recover from addiction, rather than to pick on the poor and take away the little bit of a safety net that they have. Thank you.
Thank you, Ms. Grace. Lida Shepherd, followed by David McMahon.
Thank you, Mr. Chairman, and thank you also to members of the Judiciary Committee who are here this morning. And good morning, everyone. My name is Lida Shepherd. I'm with the American Friends Service Committee, and I speak in opposition to Senate Bill 6 because I fundamentally disagree with its rationale, its intent, and its implications, and our time could be so better spent. We could use this chamber, use this time in committee, use all the conversations that we have in the hallways as a place for creative ideas, for eliminating poverty, increasing access to mental health services, substance abuse recovery centers, job training, the list goes on and on. Supporters say this will ensure people get the help they need. If that's the case, then we should be pursuing more drug recovery centers, access to higher education, I've spent a lot of time in southern West Virginia doing youth leadership development, and in Logan in particular, and some of the young people I worked with, I was very familiar with the fact that parents who they had, in one instance, one of their parents was struggling with drugs. They had to travel all the way to Huntington to access services. Now that's a problem I think that we could be addressing, that I'd love to hear discussed. But no, we are shaming low-income people. We are shaming their children. We are shaming students working minimum wage jobs while they try to get an education by invading their privacy and right to live with dignity and respect by subjecting them to drug testing when there's no, zero, zilch empirical evidence to support that this does anything. Does it create jobs? No. Does it lift people out of poverty? No. Another reason I have heard to defend this legislation is that it polls very well, it's shown. Well, this might sound off topic, but you know what else polls well? Increasing our severance tax. That polls well. That would produce enormous revenues for our state to fund all the things that I know we all care very deeply about. So in the snarky parlance of our time, hashtag just saying. So I urge defeat, opposition to Senate Bill 6. And again, thank you for the time here today. Thank you, Mr. Chairman.
Thank you, Ms. Shepard. David McMahon, followed by Jamie Lynn Crofts.
My name is David McMahon. I rise in opposition to the bill. I was a legal aid lawyer from 1975 to 2008, 30-some years. In all that time, and most of those, not most, many, I don't know the exact percent, of my clients who came to see me and who I took to court were people on a welfare check. In all that time, and I can remember one person who showed up apparently intoxicated on any drug. The number of people have said the statistics of how few people on welfare are on drugs. Some may wonder about that. I don't. Some may wonder, why is that? The answer is really very straightforward. They don't have any money to buy the drugs. I'm going to hand in as a document a page from the West Virginia Income Maintenance Manual. That's the welfare manual. It says how much the checks are. For a family of 4, mom, dad, 2 kids, a welfare check is $384. $384 for a family of 4. Yes, they get food stamps, but how do you pay rent? How do you pay utilities? How do you have transportation for a car on $384 and afford drugs? The answer is they don't have the money to buy drugs. That's the principal. That's one of the many reasons why so few people who have been tested in other states, when they apply for or are receiving welfare, are on drugs. Thank you.
Thank you, Mr. McMahon. Jamie Lynn Cross, followed by Sam Hickman.
Thank you, Mr. Chairman. I'm Jamie Lynn Crofts, and I'm the legal director of the West Virginia ACLU, and I'm here to speak against Senate Bill 6 because of the serious problems I have with the constitutionality of this bill. Generally, before the state can conduct any search, it needs both probable cause and a warrant. The Supreme Court has long held that a government-mandated drug test constitutes a search. As a federal court here in West Virginia noted in 2009, not only does drug testing qualify as a search, but it is particularly invasive because drug testing, especially by urinalysis, intimately involves an individual's personality and bodily integrity. SB 6 requires TANF applicants to go through a drug screen, but doesn't go into any detail on what the drug screen will entail. This alone could be a Fourth Amendment violation. The questions asked could easily, and likely would, reveal personal information about the people applying, including medical information that many people would want to keep private, such as a person's family history, pregnancy status, or medical conditions. Requiring persons to turn over this type of information just because they're applying for government assistance is, in itself, problematic. Even more troubling is that SB 6 applies a reasonable suspicion standard rather than requiring probable cause. The Supreme Court has said that the only way to justify a search using reasonable suspicion instead of probable cause is when there is a sufficiently high probability that criminal conduct is occurring. But that simply isn't the case here. TANF applicants are no more likely than any other segment of the population to suffer from substance abuse. The sections regarding CPS and criminal investigations also have constitutional implications that I don't have the time to get into today. The only two federal cases have been resolved regarding the constitutionality of drug testing welfare recipients, one in Florida and one in Michigan. In both cases, the drug testing scheme proposed by the state was struck down as unconstitutional. Put simply, TANF applicants do not have a diminished expectation of privacy. Because the Fourth Amendment and Article 3, Section 6 of the West Virginia Constitution explicitly protect everyone's right to be free from unreasonable searches, the state has a high burden to meet before it can intrude into a person's life in such an invasive way. No one loses his expectation of privacy by virtue of his income level. What if this bill weren't about TANF applicants? What if instead it were about obtaining a government permit in order to carry a concealed firearm? Should each person filling out the application be required to provide invasive personal details about himself? If the government isn't satisfied with that personal information, should that person have to pee into a cup to please the government in order to get that permit? After all, the government does arguably have a strong interest in ensuring that people with firearms aren't on illegal drugs. Don't worry, I'm not arguing in favor of drug testing gun owners. I just ask that everyone here take a step back and think about the implications of this bill. It isn't just about this one issue. It's about the privacy rights of all West Virginians. SB 6 says that we, as a state, are okay with allowing the government to conduct incredibly invasive searches on its citizens with no probable cause and no warrant, even if the courts were to uphold such a law. Is that really something that we would want? Thank you, Mr. Chairman.
Thank you, Ms. Croft. Sam Hickman.
Thank you, Mr. Chairman. Members of the committee, my name is Sam Hickman. I'm the Executive Director of the West Virginia chapter of the National Association of Social Workers. I didn't quite come here directly from the hospital, but I am recuperating from a hospital stay, but I'm here because this issue is so important to us. We stand strongly opposed to Senate Bill 6. To be poor is to be overwrought, to be overstressed, and quite frankly, to be incredibly resourceful in order to try to make ends meet. People do not choose to be poor. I realize that this policy, quote unquote, polls well, but the legislature's job is to consider facts, not hearsay. How many TANF recipients are there in West Virginia? A member of the Senate told me that when he has conversations with folks who complain about the number of people in public assistance, he asks them, how many people do you think receive a check from the state? And they say, I don't know, 1 million? 600,000? He says, between 6,000 and 7,000 people receive a TANF check, and most of those are children. We're talking about 2,000 people, perhaps. One provision of this bill would allow DHHR eligibility specialists to visually determine reasonable suspicion. This is unacceptable. DHHR asked for an improvement package in order to hire more eligibility specialists, but they probably won't get that this year. The caseloads for our eligibility specialists are astronomical. We're asking them to do more. Not only that, our overworked eligibility workers are technicians, not substance abuse and mental health specialists. Any determinations that they might make in this regard for reasonable suspicion would be highly suspect. Programs are already in place to identify and foster the inherent strengths of these individuals on public assistance and their families. Programs like Good News Mountaineer Garage, which in its own limited way can provide a vehicle to a deserving family identified by an eligibility specialist as particularly in need and worthy so that they can get to school or work. Let's enhance the strengths. Let's take a strengths-based approach rather than continuing to punish the poor. Thank you.
Thank you, Mr. Hickman. And to all our presenters, we appreciate your input today. We have some time for questions from members of our committee. If our committee members have questions, please identify the person to whom you want the question addressed, and we'll ask that person to return to the podium. Are there questions from our... Yes, Delegate Fast, do you have a question?
Yes, Mr. Chairman. I would like to direct a question to the Director of the ACLU, if I may.
Gentlelady, would you return to the podium, please?
Thank you very much for being here. Just had a question. If the welfare recipient gave consent for the urine screening, a drug test in general, would that alleviate your concerns under the Fourth Amendment?
Well, the way that the bill is currently written, a person would technically have to consent because you can't forcibly remove their bodily fluids. But courts have actually held that that type of coercion does not count as consent under the Fourth Amendment, and so no in that situation.
Okay, what if it was written consent, not just a verbal on the spot, but written consent?
No, because welfare recipients have a property interest in the assistance from the government, and that has been recognized by the United States Supreme Court. It would still be seen as coercive, and also in other drug testing cases, for example, students participating in extracurricular activities were required to consent before they gave their urinalysis, but the Supreme Court still analyzed it as a search and did not accept consent as an argument from the state.
So you don't believe any form of consent would be valid and alleviate your concerns under the Fourth Amendment?
Not in this situation, because requiring the drug test in order to receive the benefits is inherently coercive.
Thank you.
Any other questions for Ms. Croft? Delegate Schaefer.
Thank you, Mr. Chairman. Do you think it's legal to drug test school bus drivers?
Yes.
How come?
Because that poses a substantial safety risk to the students. And the one place where the Supreme Court has upheld suspicionless searches is when a person's job involves safety. And so a school bus driver would be a part of that group of people.
Do you think it's legal to drug test construction workers?
If they're working for the state, that is probably something that the Supreme Court would uphold, yes.
Okay, why, if they were working for the state, would it be legal?
It would be legal because, again, there's a substantial safety risk in those types of positions. The courts would look to make sure that each job does actually involve a safety risk. There was actually a case here in 2009 where the Kanawha County Board of Education wanted to drug test all workers who it said were engaged in safety-sensitive positions, and the court struck down that law as unconstitutional because it said that not all of the people who were defined as having safety-sensitive positions in the schools actually did.
So would you consider it a safety issue if we've got young children in a household where drugs are being used?
Perhaps, but that sounds to me like a safety issue for DHHR or CPS and not the court, and not a...
All right, thank you.
Other questions for Ms. Croft while she's at the podium? Gentleman from the 63rd, Delegate Folk.
Thank you, Mr. Chairman. You just said that that's a job for DHHR. Well, who implements the food stamps in the TANF? Isn't it DHHR?
Yes, but this bill also requires an investigation and also allows this information to be turned over to law enforcement, which raises additional constitutional issues.
Well, yes, and in Child Protective Services, when they find a problem too, and if it's a significant problem, they would turn it over to law enforcement, wouldn't they? So what's the difference?
Because here the state is requiring a drug test with no suspicion of these people actually.
Well, I believe this bill has been narrowed extensively to the original concept and what's been applied to most other states. Wouldn't you agree with that?
The two states where the law was actually seen through, where the court actually came to a decision on the constitutionality were more broad than this. However, I believe that there are other states that have that have been looking at a similar reasonable suspicion standard.
Make sure I heard this correctly. The two states where the courts have had a problem with it was much more broadly defined for the drug testing. Is that correct?
It was suspicion-less.
Yes. So we're a lot more narrowly tailoring our law to include only those people that have suspicion of possible drug use. Correct?
Yes, it's more narrowly tailored than those two
So the court
laws.
decisions probably are not applicable to what we're proposing here. Is that a correct statement? Wouldn't you say?
I wouldn't say that it's not applicable. There is a lot of analysis in those two decisions that I think would be used.
But neither one of those decisions were in regards to a law like we're proposing.
No, and neither is binding authority.
And furthermore, you gave an analogy about the Second Amendment.
Yes.
And you believe that discussing a constitutional right and then at the same time discussing eligibility for a government program or equivalent, or you think that's a good analogy? I'd say it's apples to oranges.
I don't think that they're equivalent. I just think that there are both situations where the government can ask for very personal information. And while government assistance is not a constitutional right, and I agree with you on that, the Supreme Court has long held that people do have a property interest in that, and as such, there needs to be due process.
Property interest for getting tax dollars that fund these programs? Is that what we're referring to?
That's what the United States Supreme Court has held.
And therein lies the problem.
Further questions by members for Ms. Crofts? Gentlelady from the 51st, Delegate Flashour.
Thank you, Mr. Chairman.
That works.
You mentioned the property interest, but the drug testing cases also involve a privacy interest.
That's true.
So when we are talking about doing a search, which is a Fourth Amendment issue, so we're talking about privacy, we're talking about search warrants, and we're talking about the first, the fourth, and the 14th at the very least.
Yes.
And the gentleman was asking you about safety issues in children and whether or not it was safe for families to have drugs in their home, and whether we ought not to authorize mandatory drug testing, or even whether we ought to target poor people for drug testing. Wouldn't you agree that if there's an issue of safety in the home, it's the same for middle-income people as it is for rich people, as it is for poor people?
Absolutely, and the studies and the implementation of these drug testing schemes from across the country have shown that TANF recipients are no more likely than any other segment of the population to use illegal drugs.
Thank you.
Are there further questions for Ms. Crofts? Thank you, Ms. Crofts. We appreciate your appearance and input. Are there other members of the committee that would desire to ask questions of other of our presenters? If not, thank you all for your attendance. We are adjourned.
You've been tuned to a public hearing on Senate Bill 6 requiring drug screening and testing of applicants for temporary assistance to needy families program. This concludes our coverage of these public hearings this morning. We will be back at 11 for floor sessions from the House and State Senate. For now, I'm Beth Voorhees for the West Virginia Channel, a service of West Virginia Public Broadcasting.